Well, thank you, Jane and John. Good evening and welcome to the program, which will begin tonight with a Henry Keogh murder trial bombshell, with a second senior state pathologist involved in the case now also in disgrace. This morning, the South Australian Medical Board found forensic pathologist Dr Ross James guilty of unprofessional conduct for withholding crucial evidence during both the Keogh trials. The question now is how many other South Australian cases have been based on flawed evidence. Graham Archer investigates.
This is actually the first finding that there has been improper conduct in the giving of evidence in the Keogh case.
It is our duty to investigate those potential errors and, if appropriate, to rectify them rather than just sweep them under the carpet.
The state's medical board, rightly, has dropped another bombshell, finding a second senior state pathologist to have withheld crucial evidence during the two trials of Henry Keogh.
So we now have two chief state forensic pathologists under a cloud.
Under a very dark cloud, because one has already been found guilty of unprofessional conduct, and in relation to the other one, the medical board has formed a view that he is guilty of unprofessional conduct, which is why they're pursuing the matter before the medical tribunal.
The latest casualty is Dr Ross James, Dr Colin Manock's deputy and his successor as the state's chief forensic pathologist in 1995, now found guilty of unprofessional conduct for his actions in the Keogh case.
It's the most serious finding that you can have against a professional medical expert witness.
It's what we've been raising for years, official confirmation of the failure of due process in the case and questions about countless other criminal cases.
Well, on my understanding, they've done 17,000 autopsies between the two of them. Dr Manock over a period of 30 years, Dr James over a period of 25 years.
Here's what happened. In December 1994, the DPP asked Dr James to review Dr Manock's autopsy of Anna Jane Chaney prior to the first Keogh trial. Though Dr Manock took minimal notes, photos or body tissue, Dr James did have 3 tissue samples, or histology as it's called, of the important bruises to the deceased's legs, including that so-called crucial thumb bruise on the inside of the left leg, which we assume he examined. Author Dr Bob Moles.
In relation to the bruise on the inside of the left leg, the slide of the tissue sample was the only evidence that Dr James had of there possibly being a bruise. And when he looked at it, it showed that there wasn't a bruise.
And yet, mysteriously, Dr James chose to tell the court all 3 tissue slides revealed almost identical bruising.
There were histological sections of the 3 bruises, and they all appear very similar.
And yet 7 years after the conviction, Dr James wrote to the DPP admitting he'd seen no proof of the key thumb bruise.
Histology failed to confirm this thumb bruise was a bruise.
So the juries in 2 trials had been led to believe there was physical evidence for the prosecution's murder scenario when in fact no such thing existed. Now at last, as they say, the jig is up, with the medical board finding Dr James...
The board determined that Dr James failed in his duty to the court and that by his conduct left himself open to the assertions put forward by the complainant that by his conduct he misled the court.
For Henry Keogh, the reasons for Dr James's failure to inform the court is not all that relevant. It's now official. His trials were conducted on the basis of evidence that was wrong. Though the board found Dr James did not intend to mislead the court, Keogh's complaint was that in effect was the result.
If the court has been misled in relation to a significant issue, and this is a very significant issue, then it really means that the conviction is unsafe and will have to be set aside.
But as a society, we need to know how such things can happen and why our authorities denied anything was wrong. One irony is that barrister Michael Abbott QC, who first came to Dr James' defence, had once been scathing of the state's forensic science credo.
The Forensic Science Centre has a rule that one scientist from the centre will not give evidence against another.
Perhaps old habits are hard to shake. But none of this would have ever come to light if not for the intervention of an expert from outside the Forensic Science Centre and an inquiring media.
Dr Manock's slides from the bruising have recently been reviewed by Professor Tony Thomas. The results are startling and appear to cast serious doubt on the Crown case.
In 2001, expert histopathologist Professor Tony Thomas, having studied the tissue samples, revealed his alarming discovery on the ABC Four Corners program.
This is the slide that was labelled as coming from the bruise on the medial side of the left leg, which was said to be the thumbprint. I see no evidence of bruising whatsoever. I don't see how on earth you can diagnose this as a bruise.
His finding meant that without the key thumb bruise, the grip theory had been pure speculation.
The then DPP said or implied that this was the one indication of murder, i.e. the grip mark. Now, if that is so, then it makes the pathology of that alleged mark of vital importance.
Professor Thomas's expertise was such that no one doubted his diagnosis. It caused an instant flurry. A week after the broadcast, Dr James made his startling admission in this letter to the DPP.
Professor Thomas claimed the histology of the thumb bruise failed to confirm this was a bruise. I agreed with him.
What's more troubling is that months earlier, Dr James had written to the DPP backing the claims made by his colleague Dr Manock in court.
Examination has confirmed that the apparent bruises from the three areas on the legs were in fact bruises.
It would appear that Dr James did a backflip.
He's supposed to be interpreting the same evidence. The evidence hasn't changed, but his opinion appears to have changed.
For the next 7 years, our authorities have tried to sweep this all away. But now this travesty has at last been officially acknowledged. The medical board finding Dr James to have had
a flawed and untenable understanding of his role as an expert witness.
Well, it's really quite a shocking finding, because at least the chief forensic pathologist in the state must have a clear and detailed understanding of the role of an expert witness. That's the principal task they have to undertake.
Dr James added to the seriousness of his failings by telling the board he didn't consider the truth about the bruise particularly relevant, an attitude the board considered remarkable.
It is not his responsibility to decide which is what it may be relevant or irrelevant. That is for the court to decide. That is not the role of an expert witness.
If the jury knew what we know now, what might they think?
Well, I'd be very interested to find out, because I think that information whereby Dr Manock and Dr James now apparently also agree that there's no evidence of bruising, that may be very influential to a jury.
The board, in their decision, go on to say
it was ignorance or disregard of his responsibilities rather than a deliberate desire on his part to mislead the court which led to his conduct.
But Dr James' sin was not just failing in his duty to the court, as the board found. It in fact went further. He continued to back Dr Manock's speculation about a grip mark despite effectively conceding there was no proof. And it's not the only time Dr James has been criticised for indulging in unprofessional speculation.
I think that's borne out in the Straker versus Queen case, where it is stated quite convincingly that an expert witness should not speculate in this way.
And in that case, that involved Dr James as well, didn't it?
I gather it did, yes.
Trouble is, who can we now trust to clean up this mess? Remember, it was partly Dr James who our Attorney General Michael Atkinson relied on when he addressed Parliament on April the 1st, 2003 in his attempt to deny the very facts now confirmed by the medical board. Atkinson told the Parliament,
"Today Tonight claims that important pieces of evidence were withheld from court. This is wrong. I deny it. I deny it. I deny it."
Well, it's a foolish and ignorant statement.
Though we warned him, the Attorney-General chose to attach his name to this monumental disaster. His choice now is to resign or repent.
He must first of all refer the Keogh case back to the Supreme Court, as we have previously asked him to do in a number of the petitions, and let the court sort this out.
And let's not forget how many warning signs there've been that a storm was brewing. It's well documented that the past cases of Dr. Manox that have come under scrutiny were found to be flawed. But nothing was ever done. Now, Dr. James, who worked under him and took his place, has also been found to not understand his role.
And now we're seeing the price that might have to be paid for ignoring those warning signs.
Of course, we've also seen Dr. James's successor, Dr. Alan Carla, quietly slip out of the state recently, after he too was found to have acted unprofessionally in the double murder of Pam and Bill Waitman in New South Wales prior to his appointment here.
For 2 years, we were told by Dr. Carla, the forensic pathologist, who's worked on some very high-profile cases, we were told by him a scenario of what happened to Pam and Bill, which was totally bogus, wasn't even in the ballpark. How can we have a forensic pathologist get it so wrong?
And as with Dr. James, the Attorney-General used Dr. Carla to continue his desperate effort to defend Dr. Manox's flawed forensics. More recently, we've had a government report into the Keogh case that's been kept a secret. And 2 years ago, the former medical board gave Dr. Manox the all-clear, even though the notes prepared by its own experts described his work as incompetent.
There has to be an end to this soon before it sucks more people into this scandal, doesn't there?
There should have been an official investigation into this matter when it was first raised, 6, maybe 7 years ago. But unfortunately, in the meantime, a number of people have purported to have a look at it and say that everything's okay.
I very firmly believe now that we have a moral obligation to society and to the public to put an end to this saga. And the only way I can see that happening is to have a full judicial inquiry or review into the whole case. I cannot see any other resolution.
And while we should compliment the current board, after a shaky start, for recognising what professional conduct demands, it's now time to face up to the whole truth.
It's all on the record. This is not going to go away, is it?
No, this definitely is not going to go away. And if officials in South Australia don't get on the right side of this, then they'll be subject to the inquiry the same as the rest of the people will be.
And Dr. James, who's seeking leave to appeal the decision, has been censured over his conduct. And while the medical board's responsible for maintaining professional medical standards, it's our chief law officer's duty to ensure the criminal justice process is not perverted by flawed evidence. This afternoon, Graham Archer put this proposition to the Attorney-General, Michael Atkinson.
Graham Archer from Today Tonight. Can I ask you for a comment on the medical board decision announced today that found former chief forensic pathologist Dr. Ross James to be guilty of unprofessional conduct for misinforming the jury in the Keogh trials?
My understanding of the medical board decision was that it found that Dr. James was wrong not to volunteer certain evidence. In fact, he wasn't asked the question by Keogh's defence counsel. I'm also advised that Dr. James, who's now retired, will be appealing against that decision, and comment from me would be most appropriate when that appeal is resolved and we have a final decision.
But we now have two senior former chief forensic pathologists under a cloud over this case. The fact that Dr. James is an expert witness and was described by the board as having an untenable understanding of the role of an expert witness means that he should have provided that evidence to the jury, and the medical board said that act was remarkable and that it actually affected the outcome of the jury's deliberations. Now, how much more do we need for justice to prevail and for due process to operate in this state?
Yes, due process is operating, and the matter will be determined finally when Dr. James's appeal is heard, and then you and I and everyone else can comment on what is a final decision.
But due process is about providing evidence to the jury, scientific evidence, and Dr. James is not denying that he didn't do that. He's claiming that he wasn't asked, but it is the role of an expert witness to provide expert evidence.
Yeah, I understand.
Now, so we have
I understand
two juries.
What's at stake, and what I'm telling you is that I am not going to give a temporary comment while an appeal is in train. And when an appeal is decided and the matter is finalised, then I will be open for questioning as the Attorney-General at that time. And I will not refrain from comment. But it would be highly inappropriate for me to canvass a decision which is subject to appeal.
But in 2003, you told the Parliament that you personally denied that evidence had been withheld from the court.
Well, I would have to look at that. You've misquoted me in the past.
No, I have not.
You've misquoted me
never misquoted
repeatedly, and you have obscured from the public of South Australia the evidence regarding Henry Keogh lying in the aftermath of the death of Anna Jane Cheney, and you have obscured deliberately from the public of South Australia the evidence regarding the insurance policies. For the past few years, you have refused to run on your program that Henry Keogh falsified and admitted falsifying the signature of the deceased on life insurance policies running to millions of dollars.
Why would he make that admission if he was trying to hide something? Why would he actually volunteer that information?
Why won't you let the public of South Australia know that information, Mr. Archer?
I've said it many times. We've actually
Not in recent years.
Yes, we have. But the key thing here is that two senior forensic pathologists misinformed juries in this state. Is that okay by you?
No, it isn't.
And you denied that it happened in Parliament in 2003.
I will check the quote because you have misquoted me before, and you have...
well, you're on a mission of misinformation about this.
No, you are on a mission of misinformation.
You have not done the public or
and
the justice
you've lost
system.
2 defamation actions just recently, and your program fails to tell the public...
That is absolutely wrong.
What happened in the High Court and what happened in the full Supreme Court,
an argument.
You cover it up.
What rubbish. That is merely an argument.
Sure.
Compensation for the Mulligan inquiry.
Well, as you saw there, Graham's questioning was interrupted by another reporter. But after the break, see the Attorney-General get even nastier when asked about another controversial issue in which he backs the wrong side.
You sneered at the whole... Can I answer the question?
No, let me ask the question.
Could I answer the question, Mr. Archer? You are so dishonest.
I have not asked the question, so how do you know?
Well, now for a real eye-opener. Following on from questions about Henry Keogh, Graham Archer quizzed the Attorney-General, Michael Atkinson, about his dismissive attitude towards an inquiry into child abuse when it was first proposed 5 years ago. As you'll see, the Attorney-General completely lost his cool, showing that playing dirty comes so naturally to our Chief Law Officer. Here's the whole exchange.
On the Mulligan inquiry, you sneered at my program and me personally.
That's another of your lies, Mr. Archer.
You did.
Graham Archer from Channel 7's Today Tonight was calling for a royal commission into child abuse in South Australia covering a period of 30 to 40 years. and the barristers were all joking that, well, tongue-in-cheek, that this was a tremendous idea because it meant $35 million would be spent on them.
On the radio?
I didn't sneer.
Yes, you did.
You
sneered at the whole...
Can I answer the question?
No, let me ask the question.
Could I answer the question,
I haven't
Mr.
asked
Archer? You are so dishonest.
I have not asked the question, so how do you know?
Because I know what it's going to be.
Well, no, you don't.
Because what you've done...
That is unprofessional.
...is you have said that I answered one particular question when in fact that wasn't the question at all. What you do...
What rubbish.
...is
what
you...
rubbish.
...is you misalign questions with answers to
you were on the
obtain
radio.
what
You were on the radio.
Yes,
you quoted...
Radio 5AA, and I was discussing a royal commission. The proposal was your proposal that the allegations from wards of the state ought to be before a royal commission.
A commission of inquiry.
That they ought to be able to make those allegations in public before television cameras.
No, I didn't say any of that.
Before television cameras underprivileged.
What nonsense.
So that in particular you could broadcast without liability Wendy Uthing's allegations.
Oh, shut up.
Now,
for heaven's sake,
is that professional?
Well, no, but you're just talking rubbish, and you know you are.
My answer was what my response was to a Royal Commission. And you know, I was opposed to a Royal Commission then, and I was opposed to a Royal Commission now.
Over a long period of time.
But I was a member of Cabinet that brought in the Mulligan Commission.
Well,
we achieved it. Against you, we achieved it.
It was forced on you by public demand, but you scoffed at the notion.
No, I didn't scoff at it, and it's just part of your deliberate campaign of misrepresentation. You are not bound by the journalistic code of ethics, and you behave accordingly.
Well, what about the rules of Parliament? What about misleading the Parliament?
Yes, well, I haven't done
You are famous for it, and I can give you, if you like, I can give you
Very
chapter
few
and
journalists threaten politicians with solicitors' letters. That's how courageous you are, Mr. Archer.
And, well, not so many as I've got from you. And you get the government to pay for yours.
No. That's
you
a
don't.
lie, a complete lie.
Oh, I thought you...
Another lie from Graham Archer.
No, that's right. Mr Caracas used to do it for you for nothing.
The government hasn't paid any of my legal fees.
Mr Caracas did do it for nothing, didn't he? He did do it for nothing.
Any questions from legitimate journalists as distinct from propagandists and pilgerisers?
Graham Archer there with a flustered Attorney General. Now, what happens when you're the victim of crime and the perpetrator is a policeman? That's